The defendant takes that knife, and it's clear at this point that he stabs him several times.
Everybody goes to the convenience store. Everybody always wants something. It's recession-free.
Mark Garrity came and charged him as Taz was bending over and hit him forcefully in the head.
I am a public business, and we get them all.
Now for what's tipping the scales, deliberations continue this morning for the jury in the convenience store murder trial of Taiseer Zarka. He's charged with second-degree murder, this for the stabbing death of his customer, Mark Garrity. And Zarka claims that he had to stab Garrity in self-defense after the two got into a fight over whether or not Garrity stole a bottle of Gatorade. The jury deliberated for over 5 hours on Tuesday before they were sent home for the day. They're going to come back today. But the jury yesterday asked to re-watch surveillance video of the altercation, which the judge did allow. They also asked for transcripts of the testimony of a store employee. The judge denied that request for transcripts, telling them they'll have to rely on their own memory. And they also asked if Taz had the right to search the bag under North Carolina law. So what do these jury questions mean for Zarka's outcome? Let's bring back in our guests to discuss this, to attorneys Taiseer Early and Franz Borghardt. Taiseer, let me start with you. Just focusing on the 5 hours of deliberation in this case and the fact that they wanted to re-watch the surveillance video and the store employee testimony they wanted, what is that telling you about where this jury may be leaning?
They may be leaning towards a conviction, and here's why. When you first watch the video, it's not what happened at the end of the altercation, it's what happened at the beginning. He was walking towards him in an aggressive stance. He pulled his book bag away from him. And I think that the jury is trying to wrap their mind around this being a bottle of Gatorade that costs less than $4 versus the victim in this case, let's say Robin, and taking all the money out of the cash register and being the initial aggressor. This is a battle of whether it was theft and he was trying to retrieve his items back, or whether it was self-defense. And I believe he was aggressive. And this case reminds me of Latasha Harlan's, the 15-year-old that was murdered, executed, just for a bottle of orange juice. I think that he was aggressive and he wanted to prove a point because he was tired of customers coming into his store and stealing from him. So I believe they are leaning more towards a conviction.
Franz, the jurors also had a different question about the search of the bag and the North Carolina law. So the defense attorneys have said that Zarka felt that he had a right under North Carolina law to search, to detain, almost a citizen's arrest. So the jury asked if he had the right to search the bag. The judge said yes, but only if the person consents, and read them this jury instruction. This is the pattern jury instruction there in North Carolina that says that you have the right as a private citizen to detain someone if you witness or you have probable cause to believe that they committed a crime involving theft or destruction of property. And it has to be reasonable in terms of the circumstances, what they're doing. They also have to contact police immediately, something that Zarka didn't do, but he did tell someone else to contact police as he was in this struggle. What do you think this says about the jury deliberations, where they're getting very specific about the law?
So it's clear that the victim, the deceased, did not give consent to search the bag. That's problematic for the defendant. I think the jury, they could be moving towards conviction. I think there may be a divide, actually. I think it's more likely that they're going to hang. I could see how reasonable citizens could be very divided on this. It's hard to argue self-defense in this case. It's hard to argue self-defense over a Gatorade in a bag in this case. In the same breath, I could see a citizen saying, you know what? You go into a store, you shoplift. He has a right as the owner to detain. He resisted the detaining. Was it excessive force? Yes, but maybe they don't want to convict him of the top charge. Maybe they want to do a lesser and included charge. I don't know. I do think I agree with Taiseer. This is just a lot for a Gatorade bottle. This could have gone totally different. He could have called the police. The cost of a Gatorade bottle does not equate to the cost of a life. $339 is what he said on the stand was the cost of that Gatorade. Let's listen back to what he said he heard from the victim before he stabbed him, and maybe that will change our panel's mind. Let's listen.
What is Mr. Garrity doing with his right hand?
He's pressuring my hand, squeezing my hand to take it off the bag.
Did he physically grab your hand?
Yes, squeezing, grab, bending.
Was he twisting your arm?
Yes, sir. He said if I open my bag, I'll stick my pistol.
So stick my pistol up a certain area is what he says he heard before he stabbed. Casey, does that change things in terms of if the jury might be thinking, oh, he didn't fear for his life, he was just angry, but he's saying he thought there was a weapon in the bag. It's not about a Gatorade anymore.
Not at all, because it doesn't change the fact that he was already standing guard with that knife in his hand. So he was ready for a confrontation, and he was ready to put up a fight. Once again, it goes back to what was being done, what you believed. You weren't afraid. You were protecting your property, and that was a bit excessive. And now you're saying that he made threats to me. Well, what was he supposed to do when you have a knife aimed at him? You're being aggressive. He doesn't want you to touch his belongings. So I just think that the punishment doesn't fit what occurred. And I do believe, once again, that the jury is leaning towards a conviction because he did not take the proper steps.